exceptionally, we're actually not going to speak about the regulation or the directive. We're going to talk about competition law, because it is often overlooked that competition law can play a very important role in creating a culture of data protection, in providing instruments to the users, to the citizens, to claim adequate data protection from the controllers.
Traditionally, the storage and treatment of personal data has been the province of laws and regulations designed to protect the privacy of citizens, and I believe that this will remain of paramount importance in the foreseeable future. However, the commercial value of personal data has grown exponentially. In spite of this, we in the Commission have yet to handle a case in which personal data were used to breach EU competition law. But we cannot rule out this eventuality. In time, personal data will become a competition issue. For instance, if customers were prevented from switching from a company to another because they cannot carry the data alone. I believe we are only at the beginning of a proper governance of privacy rights and of the commercial use of personal data. There is clearly a trade-off here between risks and benefits. Is wise to leave the search for the right balance to the individual? Can the market strike the balance? Or perhaps it's better and safer to look for stronger regulatory solutions? These questions are open, the debate is necessary, but if I participate in the debate, I will say yes to the last of the three questions. We need to better regulate, and we need to be extremely vigilant from the competition policy point of view. One thing I am sure of is that we must find a way to preserve the right of all Europeans to a private and dignified life, where their preferences, conversations, and whereabouts are not systematically broadcast in cyberspace.
In a competitive market, companies compete to introduce business models and technological solutions that satisfy consumers' demand for privacy protections. A dominant firm might not have the same incentives to invest or invest as much or invest as quickly in adopting privacy-enhancing business practices or developing privacy-enhancing technologies if it feels confident that the lack of competitive alternatives for consumers gives those consumers higher tolerance for weaker privacy protections and technologies. When crafting remedies, competition regulators might want to consider the extent to which a dominant firm might be able to extend its monopoly through its control over user data and ensure that any remedies would address this potential risk. In many cases, these remedies would promote the goals of both competition and consumer protection law. After all, these laws do have complementary goals. Competition law strives to ensure that consumers have a range of choices, while consumer protection law seeks to ensure that consumers have truthful and accurate information when making those choices.
Privacy as a competitive advantage. Now, there is a lot of interesting questions around this. Whether a competitive market will drive any privacy-friendly or compliance-friendly processes. Well, I would make this point first of all. Data protection is not one attribute. Privacy is not one attribute. It consists of a raft of interlinked attributes and standards around fairness, transparency, choice, legitimacy, retention, minimization of data, security of transfer, and so on. At best, my view is that the market will only manage to drive little bits of this. Maybe it will drive security. I think that's very possible. Maybe it will drive data minimization in some defined blocks, but it will not drive, as a whole, our move in Europe towards better privacy protection.
Competition in itself or competition laws are not going to do the trick, but I do think that we need them, because again, if you make a parallel with environmental regulation, for example, where we had the principle of the polluter pays, which always risks to turn into paying to pollute. We don't want the same to happen with privacy. We don't want there to be privacy rules and very severe sanctions, as we're now considering in the context of the regulation, and then companies, monopolies saying, well, you know, we're going to pay the fine because the benefits are greater. That's something that we need to avoid. So I think it can definitely be an additional instrument to help consumers not enforce the privacy rules but claim their rights, because you're absolutely right, it is a fundamental right.
It's fascinating to see how industries can reflect markets and market needs, not just because of regulation that exists, but because of popular demand. But it's very important that the industries are willing and able to reflect the market. That points, I think, to the necessity of ensuring that there is some assistance given to freeing up the market so that we can make privacy work. And please, and Rosemary, I know you said earlier, let's get the privacy and data protection regulations sorted, let's get the management of privacy sorted. I'm not so sure that that's going to work here. It may work in some fringe areas, but I think increasingly we've got to go into the competition level and see if that can assist this entire sector to move forward as it should do, in a free way.
Yeah, we're opening up new areas of debate, and we're only at the start of developing our thoughts about this. As always, we will keep you informed of future dates and future debates, and I hope to see you there again. Thank you.